Hi, I'm Bob Garrett. Hackensack University Medical Center believes that all citizens need to be informed about the important health issues that affect their daily lives. That's why we're proud to support programming produced by the Caucus Educational Corporation and their partners in public television.
Courtroom as classroom. Today's lesson, medical malpractice, next on Caucus, New Jersey.
Funding for this edition of Caucus, New Jersey has been provided by MD Advantage Insurance Company of New Jersey, New Jersey Manufacturers Insurance Group, auto insurance, homeowners insurance, and banking under the principle of stewardship. Wells Fargo, New Jersey Natural Gas, proud to support education in our communities. Johnson & Johnson, and by St. Peter's University, the Jesuit University of New Jersey. Promotional support provided by NJ Biz, all business, all New Jersey, the Star Ledger and NJ.com, everything Jersey. And by New Jersey Monthly, the magazine of the Garden State, available at newsstands.
Welcome to Caucus, New Jersey. I'm Steve Adubato. You know, we've all seen countless court trials on episodes of Law & Order and watched them in movies. But have you ever really wondered what really happens during a trial? Here to give us an insider's look at a medical malpractice trial, we have the Honorable Carol Ferentz, who is a retired Essex County judge in Superior Court, Paul Schaff, who is the defense attorney with the firm of
Orlovsky, Moody, Schaff, and Conlon in West Long Branch.
Very good. Dr. Edward Julie, director of the Cardiology Center of North Jersey of the Valley Medical Group. And finally, Marlene Taft, vice president of risk management at MD Advantage. I want to thank you all for joining us. This is interesting. We had a mock trial that MD Advantage put together back on the 29th of March, okay? And Judge Ferentz, you're going to really set up the scene for us because you were presiding.
I was.
Yes, and let's set the scene because we can't do the whole trial again. But the purpose of the trial was to bring together physicians, lawyers, and interested parties who cared about a case and the implications of this medical malpractice case. There was a patient who was brought in for a hip replacement, right?
Correct.
And the situation when she goes in for hip replacement, there's a cardiologist involved because
she had a history of some cardiac arrhythmia.
Okay, before we go into the case, Judge, what is the role of a judge in a case like this? Because there wasn't a jury, was there?
Yes, there was. We had a jury sitting down below.
Oh, that's right. We did have, I apologize, we had a jury. Well, what's the role of the judge, and then what's the role of the jury?
The judge has a multifaceted roles. In a non-jury case, if we didn't, the judge would be the trier of the law and the fact. Since we would have a jury in a medical malpractice case, which I have to insert this first, the term malpractice kind of makes people think of bad deeds and acts by physicians. That's not what it really is. It's kind of a misnomer. It's a term that's been used. It's any deviation in someone's practice of a profession, say an attorney, an architect, people who have licenses. But the malpractice case means that they just deviated from a standard of care, and it's really the same as a negligence case. If you're driving a car, if you happen to run a stop sign, we don't say it was a mal-driving, we just say it was a negligence case, and that's really what the malpractice is. So what the judge's responsibility is, with the assistance of the lawyers before the jury gets impaneled, is to understand what the case is, set the tone of what law is going to apply during the trial for the objections to rule, to control the evidence that's going in, and then ultimately to instruct, or as we call it, charge the jury on the law, that they are then obliged to accept and follow whether or not they agree with it. The same as I always would say to them, the judge, I have to enforce the law. I might not always agree with it, but I have to enforce it, and they must then return their verdict based upon the facts as they find them, after the lawyers have presented all of the evidence in accordance with the law that I give them.
Okay, Judge Ferentz talks about standard of care. Is that the language?
Standard of care.
Doctor, I want to hear your perspective on that, but I want to hear your perspective, and then we're going to talk about why you even did this in the first place. Standard of care.
Okay, what the average physician, given their specialty, should do in the particular situation. So, but it's not just that the plaintiff has to prove a deviation from the standard of care. As the judge will tell you, they also have to establish something called proximate cause, meaning
What is
that
it?
proximate cause.
Proximate cause.
Meaning that the deviation was a proximate cause of an injury. So there's essentially two hurdles a plaintiff has to overcome and persuade the jury by a preponderance of the evidence in every case that there was a deviation from accepted standards of care, and that deviation essentially caused harm to the plaintiff. You got to meet both hurdles, and they get a questionnaire that the lawyers do with the assistance of the judge
Right.
to try and make sure it makes sense and is consistent with the law. And then the jury goes back in the jury room once all the evidence in, and after they're charged with the law by the judge, and they answer these questions within the hopefully within the confines of the law with which they've been instructed. And as a defense attorney, we always hope that they answer question number one: did the plaintiff prove that the doctor deviated from accepted standards? No. If they answer that yes, then they go to the next question: has the plaintiff proved by a preponderance of the evidence that the deviation was a proximate cause? And there's variations, and that can get a little complex depending on certain things. But for our purposes today, they would have to answer that
Okay,
yes.
clarify a couple things.
Steve,
Paul,
may I-
one second, Judge.
Yeah.
Isn't it interesting how no one was able to do that day? You were in complete control, Judge. I remember.
This is your courtroom.
But one second. Paul was the defense attorney.
No, I was I played the plaintiff's attorney.
But you're a defense attorney professionally.
I'm a defense attorney professionally.
Okay, and we
right.
do not have a plaintiff's attorney, but you can talk about both sides
Sure,
here.
sure.
Now, Dr. Julie, you were an expert witness in that case.
I was.
Do you have any deviation, if you will? You have any difference of opinion with Paul's definition of the standard of care?
There's just one item I want to mention. There is a sort of standard of care amongst the entire medical community in the United States. These standards of care are established by federal guidelines and organizations which lay out the foundations upon which we make reasonable decisions and the therapeutic implications thereof. And then secondly, there are what we call community standards of care. So I've had the opportunity to lecture throughout the East Coast, and what I've seen is that different groups in different areas practice slightly differently. Doesn't mean that one is wrong and one is right. It just means that bear with me for a moment, it just means that their interpretation of the evidence base in the literature suggests a practice modicum in this direction,
Right.
and perhaps in the northern New Jersey counties, if you will, we may do it a little bit differently.
So hold on one second.
Okay.
This particular mock trial that took place, that MD Advantage put together on the
Right.
29th of March,
Right.
takes place in Princeton, I believe we were,
Yes.
in that area.
Right.
You're saying that the standard of care, that the way this case played out, that the judge presided over with the jury, with you as an expert witness, with you as one of the attorneys, you had an opposing attorney as well. This case, which involves a woman, patient goes in for a hip replacement. Let's get a couple of quick facts, and then I'll let Marlene talk a little bit. Help me on the facts.
Okay, so she goes in for a hip replacement, and post-operatively she has some cardiac arrhythmias, so her treating cardiologist for years is called in. He leaves the management of her care, though, to his nurse practitioner.
To the nurse practitioner.
And the dispute was, and we set up the facts of the case to try and teach physicians how not to get yourself in trouble, how communication has to be good between caregiver, patient, patient's family, how documentation has to be good so that if you get sued,
Right.
that you have some basis to give me, as a defense attorney, something to argue to the jury to persuade. So in any
hold on right
event, go
there.
ahead.
Marlene, you want to pick it up from there? Go
Yeah,
ahead.
and those strategies that are used to help physicians avoid malpractice cases are not unique to specific areas of the country. They're throughout the country that we see communication, best practices, communication between provider and provider and mid-level provider.
Now stay on the case. Stay on the case.
Right.
So there was some communication problems between the nurse in the case, taking care of this patient who came in for a hip replacement, and the physician. All I know is that, as I remember it, and if I'm wrong, tell me this, what happened with the patient? She developed
hypotension, low blood pressure.
Got it.
Okay, and that low blood pressure led to a decreased blood flow to her bowel, and she started to have abdominal pain, and ultimately she developed a hole in her bowel, an ischemic or a necrotic like a heart attack, but of the bowel. So the tissue died. She had a hole, unfortunately. It's a little gross, but stool leaks out of her bowel into her abdominal cavity, and she gets something called peritonitis, which is an infection, and that leads to sepsis, which is total organ body failure infection. She ultimately dies.
And her daughter is there the entire time, keeping notes, right, Judge?
That's correct.
Judge Ferentz?
Absolutely.
Documenting all this, right?
And the important thing with the documentation from the doctors that we were trying to drive home that day is the documentation is the next most important thing to good treatment, because you could have all of the good treatment in the world with an unfortunate bad result, and that happens because bad results come not just from negligence, but they come from very good practice. But if it's not documented, the presumption is it wasn't done properly.
Clarification. Judge Ferentz, bad result does not necessarily equal medical malpractice.
Correct.
Okay. But documentation is key. In this case, didn't a lot of the case revolve around communication or, quote, miscommunication between the nurse professional, in this case, and the physician?
I think that it evolved around the miscommunication, assumptions that a physician would come in and review a chart, and a delay in just acting on clearly significant symptoms that the patient was having. So there was communication between the nurse practitioner and the patient and the family member, where the patient is indicating she's having pain, and then not bringing that information to the physician. And she independently, as a nurse practitioner, could have ordered diagnostics for this patient and could have reduced the amount of hypertensive medication the patient was getting. So there was really a limited action when there was a time of just delay.
So hold on. Doctor, is that the nurse's responsibility or is it the doctor's responsibility? Because we're trying to help folks who were not there better. Listen, this is a case. You picked the case. You could have picked a million cases. You could have put a million pieces of information, facts together to develop a fact pattern for a case. Who was responsible, the nurse or the doctor?
No,
or
so
both?
ultimately it's always the doctor's responsibility. The nurse practitioner signs a collaborative agreement with the physician who supervises her, ultimately leading to his final responsibility. However, as Marlene just said a moment ago, nurse practitioners in this state function very independently in terms of evaluating patients, ordering laboratory tests, and making clinical decisions.
State by state law?
It's a little different state by state. Now, in this particular case, which actually was a real case that I was on the defense expert, and it was modified for this mock trial several years ago, the physician alleges that he was aware of the entire facts on a day-to-day basis.
Real life, the real case.
Real life, by meeting with the nurse practitioner every day and making, if you will, verbal rounds on any patient that he did not physically see, but rather was seen by the nurse practitioner.
Good enough?
Probably not in this particular case, because this particular patient's vital signs were changing rapidly. There were new signs of ischemic bowel, as Mr. Schaff just indicated a moment ago. In my opinion, that probably merited a little bit closer observation by the physician himself.
Judge, on the question, and this is again, I don't want to turn this into a clinical program. This is for the average consumer trying to understand what medical malpractice is and isn't. I know it's case by case. But again, I want to repeat, a bad outcome doesn't necessarily mean, hey, this is a great case for medical malpractice. However, there are some cases, by the way, how did this case, should we say it?
Unfortunately, the jury was stacked. You know, I was the plaintiff's attorney. And
Time out, Judge. Wait
I
a
am
minute.
still seething from losing the case because I hate to lose, right?
Oh, is that what happens when
Right.
you lose? You say the jury was stacked?
Well, the jury was full of physicians and defense lawyers. Okay, there were no unbiased people there, but it taught us something.
But they weren't
Steve.
playing as physicians, and
No, it taught us something, and I think Dr. Julie agrees with me. I don't know if the judge agrees. There is a wide divide between reality in the courtroom and in the legal medical field versus what is actually happening in the medical field. And it reinforced my thoughts, I've been doing this a long time now, that it's my job, and when I'm assigned to represent a doctor in a case, to really educate that doctor as to what is going to happen during the course of the litigation process. So when we get to the courtroom, he's not a deer in the headlights, and that he knows that there's going to be an expert testifying that he did something wrong. There's probably going to be an expert testifying that he made the appropriate judgment in the situation.
Both experts you can find.
Most of the time, you can find, but you know.
If you can't find them, the case settles.
Yeah, but even, you know, you have to work within the confines of what is truthful and what is fair and right. I mean, if I have a weak case, you know, the judge is right, chances are, you know, I'm going to try and find and get an expert to defend my client. But if I can't, or if I'm in difficulty, you know, you can't throw caution to the wind sometimes and let a jury call. If you do the right thing, you try and resolve the case. But there are many, many, many cases that can be defended fairly and truthfully because the doctor is making a judgment call in a situation that's a difficult one.
Right.
And just because some expert for the plaintiff gets to look at the case in the comfort of his living room on a weekend, billing quite a bit of money to evaluate the case, it's a different situation than the doctor who is in the heat of battle, so to speak, and trying to make decisions in the best interest of the patient on the spot. So
Here's not a greater, but a concern I have, and I'm sure I think I'm talking for a lot of folks out there. Can you understand physicians, your colleagues, who are so concerned about being sued, your clients, if you will, the people you represent, your company, your colleagues, people who came before you, right? People who you know well, people who treat us, so concerned that they conduct themselves in certain ways. I guess defensive medicine means different things to different people, to the point where we have to be questioning the decisions they make or don't make because they're so conscious of being sued.
But I think,
ahead,
Steve,
Judge.
that the doctors and all of the public has to understand that as rigorous, as unpleasant the litigation is, I have to say it generally falls out the way it should. And I think what doctors have to learn, we all get gun shy, and you know, if something happens, we can use the tried and true, you fall off a bike, you get back on the horse, the whole thing. The doctor has been trained, and it's hard to say, but the doctor should really sit back and just do what they have to do best and let everybody else worry later on. And if something happens, they're always going to feel badly, even if there was no negligence on their part. They can't do everything. They're not gods, they're doctors. We've all learned that. And it comes out in the courtroom. But what happens with most of the doctors who get adverse verdicts, in my experience, is that they might have done a great job. It may be a questionable situation with the judgment call, and you've got one expert says it was bad judgment, the other one says it was good judgment. They have to be as interested in that courtroom scenario as the plaintiff is. Too often, doctors don't come to court. Their position is always they have their lawyer say, the doctor's not here.
I'll let my lawyer handle it. Not good enough, Judge?
That's not good enough because they'll always say, the doctor is out taking care of patients. Well,
Can't be bothered with legal matters.
The jury says, hey, they go on vacations, don't they? So why aren't they here? They have to show.
My doctor is there, and he is interested because the jury's sitting there making $5 a day or $40 a day. They want to know that the doctor is invested in the outcome.
Marlene, I want you in here. What do you tell, this is interesting, the judge brought this up. Judge Ferentz brought this up. You don't allow it with your doctors. What do you tell the doctors? This is important because that jury, I'm sure they're listening to the facts, but they want to see his or her face, that physician's face. They're nonverbal. We want to see them, experience them, right?
Yeah, it's true. And let's circle back to the whole reason why we even had the mock trial to begin with.
Which was?
And it really is to educate physicians and our young attorneys about the whole litigation process, for them to understand how we support the physicians, we educate them, and a knowledgeable and educated physician in the malpractice area really helps to turn around the case, helps to support good finding.
The jurors watch them all the time. It's not just on the witness stand. You know, doctors and all witnesses, they say, oh, well, I'm going to be on my good behavior on the stand. That jury watches that doctor's the body language, the demeanor. It's all subliminal. I even wrote an article for MD Advantage suggesting about what doctors do.
That's your publication?
Yes.
Okay. So I'm hold on one second, Judge. So what is it that you tell or try to teach these physicians about the trial process?
you know, they know that case better than anyone else, so they have an vested interest. And we tell them that they need to work with our attorneys, work with the claims representatives from the very beginning. And most important is that they report an issue very early so we can provide that guidance. Many times, if a case could have been either you know, mitigated much earlier, could not even become a lawsuit if they had the proper guidance very early on.
But saying, my lawyer will take care of it, that doesn't get it done.
It does not. They need to be
Doctor?
involved.
Simply not acceptable. I just want to speak to your point about defensive medicine a moment ago.
Yes.
Unfortunately, we live in a very litigious country.
But the judge said, come on, it plays out in the end. It doesn't really manifest itself in decisions that physicians are making that in any way could really hurt patients. That's my interpretation of what the judge said.
I have to, as a practitioner of cardiology, I need to a little bit and respectfully disagree with Judge
you better
Ferentz.
respectfully, so go ahead.
Very respectfully. and that is that, particularly since I've been doing medical mal-defense work now for about a decade, I am very attuned to how each patient's case is developing and what I see as the potential exposure and pitfalls from a legal perspective as it's happening.
Go ahead.
And I may order a little bit over-ordering of tests if necessary to rule out every potential lethal or destructive diagnosis, if you will.
Could that drive up, does that drive up the cost of health care?
And that is exactly what I was going to say. Unfortunately, that dramatically drives up the cost of health care, and from a public health perspective, this is not the proper way to practice medicine.
But you do it because?
I do it because I want to make sure my patients get the best care, and I do not want to get sued.
Have you gotten sued?
And Dr.
Hold on
Julie,
1 second. Have you gotten sued?
I have.
Do you believe that most really good, concerned, top physicians will get sued in their lifetime?
I think it is unavoidable.
Wait, hold on. Wait a minute. You want to do all the right things.
Yes.
You do all the right things. You document, as the judge said. You're meticulous. You follow up. You follow through. It's unavoidable. You're going to get sued.
Remember when Judge Ferentz told you before that a bad outcome does not necessarily indicate a deviation. However, in patients' minds, if the patient ends up prematurely deceased or if there is a severe complication, that often represents a phone call
Marlene,
to a plaintiff's attorney.
excuse me, do you tell your insureds, those docs, hey, listen, you're going to get sued?
We do. We do that, and we are there to support them. But one thing I want to bring back that we didn't touch with this case is we had the patient who was already seen by this cardiologist prior to the surgery. And we had a family member who sat there and documented, but day after day, my mother is having pain, my mother's blood pressure is low. She already knew the cardiology practice.
Right.
One phone call to that cardiologist could have then aborted all of this and immediately started some care that was needed. So if, to the consumers, if you're not satisfied, go to take the next step. Go from
Be
the nurse.
assertive, be aggressive, go
Yes.
directly to the physician.
Don't watch day by day a blood pressure dropping, more pain increasing.
Don't wait.
Empower yourself.
You have to manage
Follow
your
your
own
gut.
health.
Yes.
Good.
follow your gut, be
And
your
help
own
the doctor
advocate.
to help diagnose you.
Help the doctor to help diagnose your loved one. Go ahead, Paul.
Right, you have to be your own advocate. You know, it's funny. Doctor in the courtroom, he's in a foreign environment.
He
It's
or she.
uncomfortable. He or she. I'm in the doctor's office or in the hospital. Now I'm in the foreign environment. I'm uncomfortable, and the natural inclination, I think, of a patient is to say, "Well, the doctor, the nurse will take care of it." Understand that.
I give you all my power.
But you can't. You can't. And you know, I'm
But
in
I'm
an
in a vulnerable
advantage.
position.
You are in a vulnerable position. Your gut tells you as a patient something is going wrong. Pursue it. Pursue it. Okay. If you think there's a lack in communication between nurses and physicians, pursue it. What have you got to lose? So somebody gives you a hard time. Who cares?
Someone says, I put my faith in the system.
Not a good idea.
Not a good
In the practice,
Not a good idea.
in the practice of law, in the practice of medicine, cross your T's and dot your I's. One of the things we
Just a
tried
minute
to,
left. Go ahead, real quick.
we educate the physicians here was to say what you can do before you're sued to try and prevent the suit, or at least make your defense better when you are sued, and what you can do during the course of the litigation that can come back to bite you. Okay, so we had the defendant in the case. We did a video deposition of the defendant played by Ken Granite, very well. And
Real
when
quick.
we did it, we made him as arrogant as we could be, as he could be.
I remember that part.
So that, because a jury gets turned off by an arrogant physician.
Personality matters.
Personality matters a lot. The interesting thing was the crowd, which was mostly physicians at this mock trial, thought that was good. And they were rooting for his arrogance. When I know, and all the other lawyers there knew, that if you put that type of presentation in front of a jury, it's going to backfire.
Got it. Listen, I want to thank all of you for joining us. We've just scratched the surface of how complex it is, but you've helped the public understand. I want to thank our colleagues and friends at MD Advantage for helping to make this possible. Marlene, great job. Judge,
Thank you very much.
We are honored to be in your presence, Your Honor.
It is my pleasure.
Thank you.
The preceding program has been a production of the Caucus Educational Corporation, celebrating 25 years of broadcast excellence, N13 for WNET, NJTV, and WHYY. Funding for this edition of Caucus New Jersey has been provided by MD Advantage Insurance Company of New Jersey, New Jersey Manufacturers Insurance Group, Wells Fargo, New Jersey Natural Gas, Johnson & Johnson, and by St. Peter's University. Transportation provided by Airbrook Limousine, serving the metropolitan New York, New Jersey area. Caucus New Jersey has been produced in partnership with TriStar Studios.
This healthcare message is brought to you by MD Advantage Insurance Company of New Jersey.
Choosing a new family doctor can be confusing. Check with your health insurer to see which physicians near you participate with your plan. Find out which hospitals the doctor uses and who covers when the doctor is away. And remember to schedule an appointment with your new doctor in advance to fill out any paperwork without the added stress of being sick.